Welcome everyone here on campus, and welcome to everyone in cyberspace. Happy to have this group together to have an interdisciplinary discussion about clinical treatment decisions at the end of life and how the law helps and hurts that effort. I am joined by my friend and colleague, Adira Hulkower, who is a graduate of our master's program here at Columbia in bioethics, and is a lawyer by training, because this is in part a continuing legal education event, but mostly it's an opportunity for us to broaden the discussion about what we need to do to improve patients' opportunities and families' choices about care at the end of life, and along the way dispel some misinformation that gets in the way of people making the best decisions for themselves. For those of you who are here to get continuing legal education credit, I hope you signed in, and you need to stay till the end and sign out. We will be breaking promptly, I promise, at 8 o'clock, because I have to teach a class tonight. And I need for all of you, especially those of you who are getting CLE credit tonight, to fill out an evaluation form, because that's one of the requirements to qualify for credit. We are here at Columbia University as part of the Columbia University Master's Program in Bioethics. And if anyone is interested, after what you will hear tonight, in extending and continuing your studies of bioethics, and in particular, the interactions between law and bioethics, you're welcome to visit our website, Columbia Bioethics. We'll get you right there. Lots of information available about the program, which is available in an introductory certificate program, pick any 4 courses, or the full master's program. Samir Lada, our deputy academic director, is here and will be able to answer any questions you have at the end of the evening when I run out to go teach class. So here's a question. As the incidence of dementia increase, there is growing awareness among patients of their ability to make decisions about care, including explicit refusal of assisted oral feeding, even while receiving symptom management through hospice or palliative support. Should we support that? Who is we? We is the medical community, clearly. We is the legal community that assists patients and families and clinicians. We is the institutions that can either support patient access to a variety of options at the end of life or obstruct that. And we're going to be talking about that question this evening. So the pressing question that we have to answer is this one. Why are clinicians and institutions often reluctant to support a patient's decision to refuse oral feeding, particularly in the presence of dementia? It is often due to misunderstandings about, among other things, the CMS, Centers for Medicaid and Medicare Services, definition of abuse, neglect, and immediate jeopardy. And so we're going to drill down on that issue and try to get an understanding of how those definitions are standing in the way of people getting the access to a full range of options at the end of life. There are lots of regulatory challenges that come from the way the law attempts to protect people at the end of life. A large part of the reason that we have the difficult conversations that we do about voluntarily stopping eating and drinking, VSED, just rolls off the tongue easier, and medical aid in dying, what in past years would be called physician-assisted suicide, we now call MAID. So we'll use those acronyms a lot tonight just to keep the discussion moving forward. VSED and MAID are 2 options. They aren't solutions in their entirety either, or even in combination, but they ought normatively to be part of what is available to patients and available as options for family members who have to make decisions about patients. And for that to happen, doctors and lawyers need to work together So what caused us all to be here today? Obviously, some people are here for the CLE credit. Some people are here because they have family members who are facing the kinds of challenges we're going to talk about. Some people are here because they're either in this field or want to get into this field. But the main reason you're all here tonight is because I attended a legislative hearing a year ago this past May on the proposed New York medical aid in dying law, which is modeled on the Oregon law and in part on the Washington law. And it is working its way through the legislative process. But as I was preparing my testimony for the legislative hearing, it became clear that the two sides in this discussion, let's be hopeful and call it a discussion, that the two sides in this discussion, those in favor of medical aid in dying as an option and those opposed, are talking right past each other. And so in my testimony to the Assembly Health Committee, I promised the chair of the committee and the sponsor of the medical aid in dying bill that we can do better at educating the public, the medical community, and the legal community about what these options can do, what they should do, and what has been misstated and misrepresented about the benefits and the perils of allowing patients to refuse eating and drinking, VSED, and to ask for medical support at the end of life. So here's what we're going to cover. We're going to talk about what families and patients face when they are terminally and incurably ill. We're going to talk about the suffering that cannot be relieved with palliative care, which is part of the justification for VSED and MAID. We're going to talk about the technical aspects of these two interventions and where they fit in the larger menu of options that we have clinically. We're going to talk mostly about all of these topics from a clinical perspective, because though Adira and I are both lawyers in the first instance, we are also both practicing in clinical ethics, managing patient and family needs and disagreements with their doctors, their clinicians. So we're going to look at all of these questions from a clinical perspective and try to bring those three areas of thought, law, medicine, and ethics, together. Special thanks both for her work in this field and for helping prepare a lot of the slides you're going to see tonight to my friend Judy Schwartz, who is the clinical director of End-of-Life Choices. Two divided loyalty, what sometimes are called conflict of interest disclosures. I do serve on the board of End-of-Life Choices, so you should think about that as you evaluate what I have to say. And, excuse me?
I don't.
There you go. And you should also know that while this is obviously my profession clinically and my area of teaching academically, I'm also living this. So I have a 85-year-old mother who is suffering from very nearly fast stage 7 Alzheimer's disease, and you ought to know that that's part of my perspective as well. Any conflicts to disclose? Thank you.
None.
So, final solutions at the end of life. What should lawyers be telling doctors? And when we say doctors these days, we're not just talking about MDs, physicians. We're talking about DO physicians and doctors of nursing practice and doctors who are physical therapists and lots of other disciplines, clinical psychologists. We need to think about who needs to be brought into this discussion more broadly, because this needs to be a bigger conversation. So the nature of the problem is very sadly illustrated by two cases that come out of the western part of our continent. And we're going to look at the case of Bentley and the case of Harris from a clinical and human perspective, and then look at the law, the case decisions, and the legislation that has both created some of these problems and can potentially be a solution. So the first West Coast case is the case of Margot Bentley of Vancouver, British Columbia. She was herself a nurse, and she completed a living will and the Canadian equivalent of a healthcare proxy, and she wrote that she would refuse nutrition, nourishment, and liquids if suffering from extreme mental disability. And then she suffered from Alzheimer's for more than 17 years. She was spoon-fed in a nursing home for years, despite the family's insistence in multiple trips to court that she would never want to be kept alive in this condition. In that case, one of the judges ruled that because a spoon pushed between her lips caused her to swallow, that was evidence that she had changed her mind. It is those kinds of attitudes and that lack of insight and lack of education that we are gathered here today to organize around correcting. This next slide is very disturbing. It is a picture of the patient so that you understand what it means to keep an Alzheimer's patient fed by feeding that she didn't want for 17 years. That's how she ended her life, kept that way for all that time because someone very patiently, and I accept with all of the best of intentions, would push a spoon up to her lips, which triggers a rather natural human reaction to swallow. And that went on for years because the judge said, oh, well, she's swallowing, so that means she changed her mind about her earlier stated refusal of eating and drinking. This is Nora Harris, the other case from out west. And to look at her, she seems pretty healthy. She has a little bit of a blank stare. That's her husband next to her. She has no idea who he is. We get calls at End of Life Choices New York that are received by Judy Schwartz, who is our clinical ethicist, who helps families deal with circumstances that they never contemplated or that they contemplated and they thought they had addressed. And this can be true for Alzheimer's dementia or all of the other forms of dementia. And unfortunately, a lot of those calls come in at a point in time where it's too late to do any of the things that we are able to do to help families and patients prepare and get the end-of-life experience that they desire. Hannah's daughter was one of those patients who called Judy. And she said to Judy, we stood at the foot of her bed. Her daughter asked Judy, what did I do wrong? Because before her Alzheimer's diagnosis, they had met as a family, they consulted an attorney, they prepared what they thought was all of the necessary paperwork, but nobody contemplated that they needed to specifically address voluntarily stopping eating and drinking pursuant to an advance directive before Hannah lost decision-making capacity. So Hannah is now 99 years old. This was about 8 months ago. 16 years earlier, she was diagnosed, and she's been in diapers for 9 years in a hospital bed in her home in the living room. She no longer speaks or moves purposefully. She doesn't recognize her only child or longtime caregivers. We'll be able to describe that circumstance clinically in a few minutes. So Hannah was spoon-fed 3 times a day, and like most human beings, when a spoon was not just put up to her lips, but put into her mouth, she would swallow. And when all you're doing is lying in bed, the reality, for better or for worse, is that you don't need a whole lot of nutrition or a whole lot of hydration to keep going for years. The hospice said that she has to continue to be spoon-fed until she forgets how to swallow, which is a horrific, horrific circumstance for someone who specifically said when she had decisional capacity that she never wanted to be this way. And it's unfortunately impossible to know how long this final stage of Alzheimer's dementia is going to last. So these cases drew a lot of attention out west and led to the creation of the first advance directive for withdrawal of oral, not artificial, by mouth, by spoon, eating and drinking, pursuant to an advance directive in patients with dementia. And the Washington bill contemplated when we ought to understand that a patient wants this advance directive to kick in. So here are the solutions that are available to us in New York, or will be available, I am hopeful, very soon. Voluntarily stopping eating and drinking. That's the decision that any of us can make as a matter of legal right today. Doesn't matter if you're sick or well, terminal or chronic, that is a legal option. V said by advance directive. You can say that when I reach a certain point in my disease progression, let's say you've had a stroke, that you want oral assisted nutrition and hydration discontinued. V said by advance directive for dementia patients, which is just another category of patient from a legal perspective, but from a psychological and emotional perspective, it's kind of different, because when you get into the later stages of dementia, it's hard to recognize that the behavior that is observable clinically is not an indication of willful conduct by the person based on their values and preferences. So in New York, we took the idea of an advance directive one step further. We actually created an advance directive through End of Life Choices New York that gave New Yorkers the ability to either say, if I reach a certain stage, it's level 7 on the FAST scale, we'll get to that, I don't want to be fed, or I only want to be fed if I demonstrate that I appreciate the experience of having that nutrition. So that is either a successful outcome immediately, typically by dehydration, typically in 1 to 2 weeks, sometimes as short as 3 days, but typically it goes longer, with the cause of death being dehydration. Or, get to the right slide. Or the comfort care option, which is the circumstance where someone can say, even when I am at that advanced stage of dementia, I want to be fed orally, but I don't want to be fed when I am no longer demonstrating an interest in being fed. That is, I'm not enjoying my food. Quick story, we have a friend whose father was in advanced stages of his disease, and our friend said, it's terrible, he won't eat. All he wants is hot dogs. I tried to be compassionate, but then I said, well, so let him eat hot dogs. Our friend said, but they're not good for you, right? these are the attitudes that we need to work through. That's part of what we need to do. And this problem is not getting better, it's getting worse. There are 6 million Americans who have Alzheimer's. That's going to go to 14 million people by 2050. And it is more and more what we all need to worry about. So the two cases on the West Coast are what sort of focus the attention of the bioethics community, both the clinical and the academic community. But this is now becoming a more common occurrence in people's lives, which is why at the legislative hearing that the New York State Assembly organized, there were dramatically different positions between the two camps for and against medical aid in dying that were looking at the problem entirely differently, and as I said earlier, talking past each other. Those who support medical aid in dying were focused only on the relatively small number of patients, typically cancer patients at the end of life, who can't be kept comfortable by palliative care or even palliative sedation, and who want to end their existential suffering by taking medication. The other side was predominantly the religious and disability rights community, and their concern ignored that small group of patients and focused entirely on the risk, what we call the slippery slope, of end-of-life withholding of eating and drinking or administration of medication to bring about the end of life becoming a norm and something that people would sense that they were obligated to do. Now, the law has very substantial safeguards, even stronger than are present in the original Oregon statute or the several other states, 11 now, that have adopted different approaches to end-of-life choices. But we still have work to do to create a consensus around making medical aid in dying and VSED available for patients who really need it, while making sure that nobody gets it who ought not. And that's where Adira and I are doing work in our respective environments. Adira principally in a critical care hospital, me principally in community hospitals and in the hospice service, to make sure that no one is pressured into any of these choices unless it is their own choice based on their values. Please.
No, I was just going to say, when do you want me to jump in and talk about the clinical experience with some of these things?
In 2 minutes.
All right, give me the heads up.
So we want to be sure that we know that the point at which time the act of offering oral feeding to someone in advanced dementia or someone with any other disabling condition is when they wanted it to happen. And looking for that kind of an objective criteria is an important part of what we're trying to do clinically to make sure that we take care of everyone who really wants to be taken care of this way and no one who really doesn't. So we have this functional assessment staging test, the FAST scale, that has stages 1 through 7. We're all at 1, at least I hope we're all at 1, which is you're functioning normally. You can have any number of different disabling medical conditions, but if you're functioning in your normal steady state, you're a 1. When you get to 6, you can do few or none of your activities of daily living, dressing, bathing, eating, without substantial assistance. And when you get to 7, you are at the point where you don't recognize anyone, you can't provide for any of your daily needs, you're completely dependent upon care, and you can't feed yourself and can't even express your interest in being fed, other than to the extent that if somebody pushes a spoon past your lips, you'll swallow. So this is the FAST scale, stages 1 through 7. It's a little hard to read, so I blew it up. And of course, we're concerned about stage 6 and stage 7. Stage 6 requires assistance with dressing, bathing, and toileting, experiences urinary and fecal incontinence. That stage, by the way, occurs for a relatively short period of time. Stage 6, on average, lasts just 3.5 to 9.5 months. So it's a stage that you pass through pretty quickly, and you wind up at stage 7, severe Alzheimer's, speech ability declines to about 6 intelligible words, progressive loss of ability to walk, sit up, smile, or even hold your head up. So that is the objective criteria that we can apply clinically to make sure that we're not getting ahead of where the patient wanted to be. So as I said, this can be done as a complete withholding of assisted oral feeding, or it can be done on a comfort care basis. And that choice can only be made meaningfully by a patient if somebody is explaining to the patient how this would work. And that's where clinical bioethics comes in. So Adira is going to share one of her experiences with a patient who actually had to go through this process so that you have an illustration in your mind of what this all looks like. Adira?
Yeah, I guess it's not exactly a patient that went through this process, but it's a patient that sort of brought up some of these issues. So I have, as David shared, I'm the chief of the Clinical Ethics Consultation Service at Montefiore and graduate of the Columbia program. Inaugural class, I think, which dates me a little. So I guess what I look at as one of my roles as a clinical ethicist is agitating in order to resolve. And I think sometimes we need to do that. And a lot of these issues that David's speaking about are really loaded and fraught with a lot of emotion. So we have the emotion that's attached to feeding, right? Like that's at the root, I think, of a lot of the sort of pushback and distress around talking about voluntary stopping of eating and drinking, and also about seeing a loved one or die and watching that process, and what does that bring up for people. So I want to bring up a couple of points, but first I'll just tell you, I'll give you an example from the clinical setting. And this is a patient who was a 70-year-old woman who came to our hospital for an abdominal, she had abdominal cancer, came for treatment of the abdominal cancer, and had a complication during the surgery, which wasn't unforeseeable complication, but it was it was in the rarer category that led to prolonged intubation. And she woke up in the ICU, intubated, and she asked for physician-assisted suicide or medical aid in dying. And I'm actually, I think the language is really, medical aid in dying can be a number of things, right? When we turn off somebody's ventilator, that could also sound like medical aid in dying. So I think when we use that phrase, we have to be very specific about what we're talking about. She was encouraged to kind of hang in a little bit and consented to have a trach, so a tracheostomy. So if somebody's intubated for a prolonged time, it can be not great for their trachea. It can cause some of swelling around that area. I have no clinical background, so this is based on being in the hospital setting. So don't write that down and go tell somebody. And also tracheal stenosis, but also like bruising and eroding of the trachea. So they're doing a tracheostomy where the tube goes directly into the trachea is a better long-term solution. It's also more comfortable for patients. So she was given that, transferred to the floor, and then again made a request. And for physician aid in dying, is that medical aid in dying? Is that the term? Okay. So for medical aid in dying. They are just words, except they mean different things to different people, right? So she made that request again, and they decided to do a referral to palliative care to have somebody kind of sit at her bedside and ask her some questions. And she talked about a life of independence and how she had been a dancer and very engaged in this. Even at 70, she was still dancing, and she was felt very independent. And this life of being on the ventilator was not a life that she considered a life worth living. And if medical aid in dying wasn't available to her, she wanted the removal of her feeding tube and the removal of the ventilator. And she was able to breathe for some periods of time off the ventilator, so it wasn't that the removal of the ventilator would lead to immediate death. And I got a call very late at night about this case the call came from the doctor saying, well, she doesn't actually have a terminal diagnosis anymore because we did the surgery and we got all the cancer. And she's actually gonna be okay. We think she'll come off the breathing tube. We think she'll be able to eat pretty soon. And then she'll be able to start rehab and start walking. And right now she's been in a bed for 4 weeks at this point on the ventilator the entire time. And as a clinical ethicist, one of our jobs, if we can, I believe, is to slow down the process and to really be thoughtful about what the options are. And I kind of started by saying she has those rights, right? Those are her rights. She has a right to say, I don't want this. Patients with capacity, so she had capacity, patients with capacity have the right to refuse life-sustaining treatment. That's it, like it ends there. They don't have to have a wonderful reason for it. They don't have to defend their position. That was her right. But as a clinical ethicist, and I think I would actually argue even as attorneys or anybody who's at the bedside of someone, I think that there is also a responsibility to hold their hand and sit with them and ask them why, and ask questions and learn more about their story. And not for the purpose of convincing them otherwise, right? So part of that is sort of the approach to this is not, no, we want you to live, you have a good prognosis, what are you thinking? The approach is, tell us what you're thinking, what are you understanding, what are you going through? And so what I said to the team was, let's have some conversations with this patient and let's learn more about her. And the team did, and they made kind of an assessment that she was not getting a lot of visitors, was feeling very lonely, and was also not seeing past her immediate state to what was possible for her. And so what we said was, let's make sure that we are transparent with her and share with her what her life really can look like. And just as a caveat, sometimes there's an overly optimistic view that's given to patients. The doctor, the surgeon, who was a very proficient and thoughtful surgeon, was like, no, this is like looking at my patients, she's gonna do great. Like, she is strong, she's gonna do great. And so part of it was just making sure she understood that. And the other part was saying, how else can we support her? So one of the things that we did was get PT in there every day, get her out of her bed, get her moving to see that this is something that she might be able to regain some of the strength and some of what she was able to do prior, right? She had a big insult to her body, so I don't know that she was ever gonna be the exact same person that she was before, but she could be ambulatory and she can dance maybe like a little less, like, I don't know, gracefully. So I bring up this story to say that to make a couple of points. One is that patients' requests are always the beginning of a conversation, right? Refusals are an open door to say, walk in and ask me why. Or requests for aid in dying, even if we think that this is exactly what this person should be entitled to, should be an invitation to a conversation. And in this particular case, the invitation to the conversation led us to a resolution where the patient stopped asking. And not because we'd like pounded her over the head and defeated her, but because she was getting a different level of attention, engagement, and information that helped her make a different decision. But what I want to raise, and this is always important for ethics, clinical ethics is not to justify your process by the outcome. So not to say, well, because she decided to not terminate her feeding or not terminate her ventilator, therefore the ethics process we went through is good, right? I think it's solid because, it was my advice, but I think it's solid because I think it's solid, but we don't want to do that. So what I want to think about is what might have happened if 6 weeks down the line, when she no longer had her trach and she was no longer had her ventilator and she was eating by mouth, she decided at that point, I still don't feel like I feel like a compromise or a version of myself that I don't think is worth, it's a fate worse than death for me and I want to die. We've taken away at that point, by making the decision to sort of delay acting on her wishes, her ability then to say, turn off the ventilator or stop the feeding tube, and left her with very few options at this point in New York for how to be able to die, right? Because we don't have medical aid in dying, which would lead to voluntary stopping of eating and drinking. And as David was sharing, this is something that she would be entitled to have as a capacitated person. Any of us could decide right now, but it's a process that is not easy. I mean, even if it's over in 12 days, it's not like it starts and you just sort of stop and then you gradually fade. There is a lot of thirst, there's dehydration, and if it's not medically managed correctly, that can be an incredibly painful death until someone passes into the stage then when they enter into a coma. So it's not leaving somebody necessarily with an ideal choice. So that was something that we had to take into consideration, but also had to consider what are the other options available. But this is, it doesn't come up that often in our hospital when patients ask voluntarily request to not be fed. But similar issues do come up a lot where we have to sort of think, what situation are we placing the patient in if we wait? What situation are we placing the patient in if we honor their refusal, if we don't honor their refusal, and thinking through that process?
And even when medically it's very clear, and medically it's very easy to implement from a technical perspective, that doesn't make it emotionally easy at all. The only thing that makes it a little bit more emotionally manageable is if you're very clear that this is what the patient wanted when they had the capacity to make that decision. And so to achieve that, we need to do all of this. We need to get people to fill out advanced directives, including advanced directives that contemplate the unimaginable, winding up with Alzheimer's, winding up with dementia. I'm fond of saying that if you live long enough, if you don't get hit by a bus, either your mind goes or your body goes, and you don't get to pick. Most people would rather have their body go than their mind go, but it doesn't matter what you want. So we need people to prepare advanced directives. That's where clinicians, doctors, lawyers, family members need to step up and be aggressive about doing it right. And then we need to make sure that those advanced directives are widely available. Lots of people know where they are, what they say. Adira will tell you a story in a little while about a patient who just documents kept popping up. Making videotapes, which, is very easy now that we all have these iPhones or droids in our pockets. That's important. It's important for the patient so that they can express their values in their own words. It's important for the clinicians. It's important for the lawyers. Lawyers ought to be telling their clients, I get role confusion a lot. And it's important for family members because it's the reminder, yeah, this is what my mother, sister, father wanted. And though it is hard and upsetting to follow those instructions, if you see your loved one saying, this is what I want, it makes it a little bit easier. And we need to make sure that those advanced directives are very clear that even if it looks like I'm okay, or it looks like I'm happy, or it looks like I'm desirous of being fed, when I get to fast level 6 or fast level 7, capacitated me says no more.
Can I pop in there for a second?
Please.
And just talk about one of the perspectives that kind of pushes back a little bit about the idea of like desirous. So David was sharing 2 cases that talked about patients where they were like, I guess I don't want to say shoving, I wasn't there, because I imagine that the feeding was done, I'd like to imagine it was done lovingly and with the purpose of care, but if somebody is not looking to eat and they have a reflex to swallow when something's put into their mouth, I don't think that, from a clinical perspective, it is not clear that that is somebody articulating a desire to eat. But we do have to imagine situations where people have shared in their advanced directives, when I am in a stage 6, I don't want, this is not a life worth living to me, and so I would not like to be fed, but are actually asking for food and still hungry and still saying, I want water, I want to eat. And imagining what is the burden on the caregiver and on that patient who can't understand anymore. And so sometimes, I was actually telling David, so to betray, I was like a little nervous about this talk on the way here. So I was listening to a podcast about voluntary stopping of eating and drinking, and this woman was sharing how she had said to her husband, I know you're asking me for water, and I'll give it to you if you want it. I'm not going to keep it from you, but I want to remind you that you asked me not to give it to you because you didn't want to A, B, or C. Now that, I think, is an interesting approach if somebody can actually process and understand that reasoning and opt out. But what happens if they can't? Mm-hmm. And these are solutions, but they're not solutions that are without a burden on caregivers, clinicians in the hospital, right? Like for the patient I talked about, I think it would have been incredibly distressing, emotionally distressing to the clinicians to turn off that ventilator and remove that PEG tube knowing his prognosis. And it's not, and one of the arguments sometimes against medical aid in dying is that it's not in line with the task or the credo, I don't know why I'm like trying to find that word, of professionalism of clinicians who don't want to do harm. It's not part of their non-maleficence and beneficence, right? Everybody who's in the bioethics program are like, I know those words. So I think that it sometimes feels contrary to what their mission is. And so we have to imagine the impact. So when you say the word, even if somebody's desirous, it's really important to imagine what that looks like, both in the clinical setting and lying in a hospice bed at someone's home.
And as hard as that is, in an inpatient hospital setting where there are people like Adira available, or a home setting where a patient can be on home hospice and have access to my clinical services, if you're in a long-term care facility, this becomes very difficult for some good and some bad reasons, right? So as dementia becomes more advanced and more common, long-term care placement is often unavoidable because there's no other way of taking care of a patient and keeping them from developing decubitus ulcers or pneumonia and all of the other conditions that come from homebound immobility. So if you are planning for your own eventual placement in a long-term care facility because you have early onset Alzheimer's, for example, it is critically important, for reasons that we're going to get into in a moment, that you have a conversation with that administrator of that long-term care facility before you sign yourself up. And that requires that you either get it in writing from the facility or that you have a lawyer advocate on your behalf, because once you have placed yourself into the care of a long-term care facility, you have very little leverage left, very little means of negotiating or advocating for your values and your priorities. And that's because the legal history on this is pretty rocky. And in response to all of the legal complexities that have presented themselves over the years, institutional administrators and medical directors, they don't want to put their toe even near the line, let alone across the line. So there are legal implications of the history of eating and drinking as a regulated activity, and we need to understand what all of that is about and how that legal history brought us to where we are today. So think about 1914. Seems like forever ago, right? Especially to about half to a third of our in-person audience, and sorry, people in internet land, I can't see you, but this is what a car looked like in 1914. A little primitive. It could pass for a ventilator. But it was in 1914 that Benjamin Cardozo, before he became a Supreme Court judge, published a decision in a case, Schlowendorf versus Society of New York Hospital. For my students in the audience, you all know this is my favorite bioethics case. And in 1914, Cardozo had the insight to say these immortal words: every human being of adult years and sound mind has a right to determine what shall be done with his, even though Schlowendorf was Mary Schlowendorf, who had fibroids, uterine, his own body. Now, in 1914, to the medical community, that was heresy, because the predominant, and one might argue the only ethical norm that existed for doctors, was beneficence. In the extreme, we might call it medical paternalism, clearly not maternalism. The first woman in America to go to medical school, that didn't happen until 1847. And by 1914, there were almost no female doctors. And even female patients were referred to as him. But this established the notion that you have dominion over your body, and that if you don't give permission for someone to touch you at all, that touching is not just medical negligence, that's assault. And that's what Cardozo warned us of in 1914. Jump forward to 1987, the first case in New York State where someone asked for artificial feeding to be withdrawn. Julie Delio, now Julie Chase, who sued Westchester County Medical Center because she asserted that it was her prerogative to withdraw a feeding tube from her husband, who had lapsed into a persistent vegetative or perhaps minimally conscious state. And the medical center said, that's not a decision we can make. You're going to have to go to court. And so Julie went to court and won and earned the right to discontinue her husband's feeding tube, and he passed comfortably. And a year later, it happened again at Westchester County Medical Center, this time involving Mary O'Connor. This is the famous O'Connor decision in New York. And by then, the ripple effect of the Delio decision had worked its way through the medical professions and through the hospital administrative bureaucracy. And Westchester said, well, you know, you made us look foolish last time. This time we're going to go to court and get the judge to say that we are obligated to respect the wishes of Mary O'Connor's family. And they got burned again. Because this time it went to New York's highest court, the Court of Appeals, and Judge Wachtler wrote the decision in the O'Connor case, which said, no, the court in Delio, they were wrong. Unless there is clear and convincing evidence of the patient's prior expressed wish, no nutrition or hydration or other medical intervention can be withdrawn. He didn't say it, but he meant until the flesh rots off your bones, until you literally die from lying in a bed. And that was the legal standard in New York up until the adoption of the healthcare proxy law for people who actually go to the trouble of designating a healthcare agent, and then later the Family Healthcare Decisions Act for people who didn't have the good sense to designate a healthcare agent. So we have the healthcare proxy law, which gives someone that you designate an enormous amount of latitude to make decisions on your behalf, except for decisions about artificial nutrition and hydration. And in those cases, your agent can only authorize withdrawal or withholding of artificial nutrition and hydration if you have specifically told your agent, your proxy, what your values and priorities are. That was a political compromise to get the law passed. That's how politics works. So that is still an obstacle, and we're going to talk about what we need to do about that later when we talk about the solutions. The next obstacle we face is the standard of care, and that is the obligation that clinicians, let's be candid, mostly physicians, define for themselves as their obligation to patients. So Adira is going to share with us some of her perspectives from the bedside about how the standard of care informs and misinforms judgments about feeding tubes, and how that can lead to patients not getting what they thought they had made clear was their preference. Adira?
Okay, thanks.
Adira, excuse me.
That's okay. I answer to both. So I think, to me, there's a different ways of like learning and thinking about bioethics in cases and extrapolating from them. And my favorite one, and the one that works best for me, is case-based learning. So I'm going to share one more story of a patient with you, and then explore some of these issues through that. So this patient was also, I think, a man in his early 70s who came to us from a nursing home. He had failure to thrive in the nursing home. So here's some medical language for those of you who are non-cachectic, so like very, very thin, without like extraordinarily thin, and contracted. So his body, he had contractures. His body was like, I think if I recall correctly, he was kind of almost like half seated, like in fetal position, and his body was sort of like stuck that way. And that, by the way, there's a lot to say about care and, you know, the nursing home that he came from, that he wound up that contracted. That's because he wasn't moving. And he came for the purpose of placing a PEG tube because he had not been thriving in the nursing home. He also had advanced dementia. So he comes to our hospital, and he's on the GI schedule for the feeding tube, and a living will is discovered. And the living will, I'm just going to read to you from it, says, well, I'm going to summarize from it, that he does not want his life to be artificially prolonged under the circumstances set below. And that was that he either has, a physician has determined he has an incurable terminal injury, disease, or illness from which no recovery is reasonably possible. He's permanently unconscious, or he has severe irreversible brain damage. And he says that under those conditions, he does not want artificial nutrition and hydration when the application of such procedures would serve only to prolong the process of dying. So those are his wishes. And the team was like, uh-oh, we found this living will. We have to call bioethics. Does it apply or not apply to this situation? What should we do? Do we place the PEG tube or not?
And by the way, that's pretty good as these things go. We've both seen lots of much worse advanced directives, living wills.
I think what's concerning to me, to just sort of editorialize a little, is that this was done on the date of his admission to the nursing home. So he sat down and he was given this living will, and his name is blocked out so you can't see it anyway, but it's all just, you know, it's boilerplate, it's checked off. So how well do they know him? What level of conversation have they had with him? And how informed is this? Living wills are imperfect documents, and they tell us nothing about somebody's values, right? They tell us about their preferences or their wishes under certain circumstances, but not actually about, I don't even want to say values. They don't give us a narrative. I don't know anything more about this patient, no matter how many times I read this, other than he checked this box off. So the second hiccup is that they then they discovered this on the day of the PEG tube was supposed to be placed, but they already had in their hands a healthcare proxy form where he had named his sister, and they had called his sister, and she had given, who hadn't seen him in about 5 years, and she had given consent for the placement of the PEG tube. So now they had a healthcare proxy form naming a sister, and she was consenting, and a living will with wishes that were potentially contradictory to what the sister was saying. And how do we balance all of that? And I spoke with his sister, who shared that she hadn't seen him in 5 years. They were estranged. She had had no idea that she was his healthcare agent at all. The last time she had seen him had been when he had traveled to be able, he had gotten a pass from the nursing home to be able to see his mom as she was dying. And so that had been 5 years before. So imagine that her picture of her brother is somebody who is ambulatory and able to travel on a plane, not a contracted, cachectic person with failure to thrive who is unable to communicate meaningfully at all. I mean, not even, by meaningfully, I mean he's like barely tracking and talking at all. He's not saying anything. So she said to me, I want to honor his wishes, but the doctor said his kidneys are failing and he might need dialysis, and the only way he can be strong enough for dialysis is if he is fed. So there are a lot of issues with that story. So she did not want to withdraw her consent for the placement of the PEG. It was our recommendation, it was from Bioethics, that the PEG tube not be placed. And the reason for that was because, our twofold, and I'm going to kind of hit on a couple of other things that we're talking about. So one is that we had this document, this living will, and I don't like living wills. I'm just going to put it out there. Like, for the most part, boilerplate living wills. I'm not talking about personal narratives and stories. I'm talking about these kinds of checkoff forms, because I don't understand what this means. I don't know what he was thinking, but for this man, nobody knew him. His sister, even his sister, could tell us nothing about him. So this document became the only thing that told me anything about his wishes. And there is a risk always of overvaluing information when it's the only information you have, but also when it's the only information you have to recognize and act on that. And the other piece is that it was consistent with professional guidelines. So professional guidelines about placing a PEG tube in patients advise against, so when I'm talking about professional, I'm talking about like the American Geriatric Society. And I don't know, I don't want to speak for other professional organizations, but they're not the only professional organization, makes recommendations that, based on evidence-based research has shown that placing a PEG tube in a patient with advanced dementia is no safer than hand feeding, and has a lot of additional complications. This actually can be more dangerous and can shorten somebody's lifespan, because it first of all creates like an opening into their body, so that can cause infection. It causes them to be less mobile, which makes them more prone to ulcers and more pressure ulcers, more prone to pneumonias. And there's no evidence that it changes. One of the reasons that when people stop being able to eat well by mouth, it's often because they start aspirating and they can't, the food can get into their lungs, but actually the evidence says you can aspirate with a PEG tube, food from a PEG tube too. It can come the same way. So because both the professional guidelines and his wishes were so consistent, it was our recommendation to not place the PEG tube.
And one of the clinical realities that lawyers often miss, that is, lawyers who don't happen to also practice clinical ethics, is that the feeding tube does nothing to address the underlying problem that caused the patient to need the feeding tube in the first place. So that needs to be part of the education that we spread to both the legal profession and the primary care medical profession, so that they are educating patients that a feeding tube, though it might be a useful bridge therapy to get you over some acute event, it's not a solution. It's not a treatment for the underlying problem.
And I think, so some of the things that brings up, I think, for attorneys, but also the story brings up in general, are one, the inadequacies of living wills. And one additional thing about a living will is living wills are if-then documents, right? So if A, then B. So if I'm in the following conditions, then I do or don't want the following things. But the conditions that are stated here, so this is an interesting thing to think about in terms of education that I think that David is really stressing this evening, is that there were people who were saying, well, is dementia really a terminal injury? Is it really, I mean, I would say it's certainly incurable, but the way that dementia was conceived of is different than, or thought about in this case, was different than cancer, and or terminal cancer, which it probably shouldn't be for the sake of an if-then statement, but if-then statements are subject to interpretation. And so if clinicians or family members disagree about the if part being met, then we don't even get to the then, right? So we wind up with a conflict.
And this is literally an entire other evening's discussion because it's that important.
I will stop then. Now, so the second, that was like a very subtle hint.
All want to stay until 10 o'clock.
The second piece is that his healthcare agent didn't know him and didn't even know she was assigned as his healthcare agent. If I tell you this is a regular occurrence, I will be telling the truth. It happens all the time where either healthcare agents don't know they're assigned or they have no idea about the patient's wishes. And so they certainly don't know about the patient's wishes about artificial nutrition and hydration when they don't even know about the patient's end-of-life wishes at all. And sometimes these healthcare proxy forms are filled out in emergencies, right? Somebody comes into the emergency room, they're like, you gotta put down somebody's name, and they're like, okay, who's my cousin, who's my person, who's my whoever that can do this, but sometimes they're filled out in attorneys' offices or doctors' offices where further conversations can be had. And I would stress to attorneys out there that work on living wills and healthcare proxy forms to say, have you told that person? What conversations have you had? Because there is a real impact on a healthcare agent when they have to make a decision. And when decisions that are not even that complicated, when people are in positions of losing someone they love or potentially traumatic decisions feel like mountains. So you can imagine that decisions like saying, removal of artificial nutrition and hydration or a ventilator seems like, I don't know, what's a lot of mountains? Seems like a lot of mountains, like very, very, very big mountain, right? So I think that making sure that healthcare agents are educated and part of the conversation when a healthcare proxy form is filled out and that is documented can go very, very far. For both like from a legal perspective, both from helping clinicians make decisions or recommend treatment plans, but also from a position of how does this healthcare agent heal and grieve after that their loved one dies. And if they really, so the research shows that it's challenging no matter what, but surrogate decision makers who make decisions that they're clearly in line with their loved one's wishes do better. They have less post-traumatic stress from the surrogate decision-making process because they're well informed. So this case to me sort of highlights a bunch of things. One is importance of knowing professional guidelines, right? To understand how somebody might sit and say, I want your name.
That's the standard of care.
Yeah.
Right.
And to say, actually, the doctors in this case were, I think, from a period of time, I don't want to age them that much, where feeding was just feeding. You did this. Every nursing home patient got a PEG tube. And that kind of is not, it's
not
changing,
gone.
But it's not gone.
Definitely
it's not
not
gone. So it's just like, of course we feed them. And also from a nursing home's perspective, there was money tied to weight.
And there are cases that reinforce that attitude that we're going to get to in a few minutes.
So one is like the importance of sort of knowing if somebody is saying, I want everything done, and so please write that in my healthcare proxy form or in my living will, to say we need to have a further conversation. And as an attorney, you might not be qualified to have that conversation, but you're qualified to say this needs to be a bigger conversation. So how about this? Let's think, like you go, let's connect you to a doctor or somebody who has that information and be thoughtful about it, come back and let's finish that document. Plus a healthcare proxy form doesn't have to be done in an attorney's office anyway, but
The two things that as clinicians we just can't stand hearing are, I want everything done on the one hand and no tubes on the other hand. I still don't know what no tubes meant. I've been thinking about that for a long time. So these first three issues, the healthcare proxy law, complications, the standard of care, and a lot of misinformation about feeding tubes, they're the easy problems. They're the more common challenges we face clinically, but they're manageable. They're part of our normal environment in clinical ethics. Criminal prosecution, death panels, and CMS conditions of participation, those are the really thorny problems that aren't going to be able to be resolved at the bedside in a clinical sense or through education. They require larger either court, legislative, or social transformation of attitudes. So this is 2982 of the public health law. This is the healthcare proxy law. And it says that subject to any limitations in the healthcare proxy, an agent shall have the authority to make any and all healthcare decisions on behalf of the principal, but goes on to say here at the end that if the principal's wishes, third line up, if the principal's wishes regarding administration of our artificial nutrition and hydration are not reasonably known and cannot with reasonable diligence be ascertained, only a lawyer could write those words, the agent shall not have the authority to make decisions regarding these measures. Why is that in the law? Because that's what we could get past, right? It was a political compromise, and we're living with it. We're trying to fix it. More about that at the end of our presentation. So what does it mean that the agent does not have the authority to make decisions regarding these measures, artificial nutrition and hydration? Does that mean that the patient can't make decisions about artificial nutrition and hydration in, dare I say it, a living will? No, because this law only relates to the authority granted by the legislature to an individual appointed pursuant to the healthcare proxy law. So it's important to understand in terms of legislative construction and interpretation that the fact that an authority is not granted by a particular law doesn't mean that that authority can't be acted upon in some other way. This is the guidance that was put out by the health department when the healthcare proxy law was passed in 1991. I read it for the first time probably 20 years, not so long ago, and it was remarkably instructive. It actually, it was pretty interesting. Because we knew then, the legal and healthcare system, that there was going to be confusion about what had to be in the healthcare proxy. So they had frequently asked questions. Must evidence of the patient's wishes about artificial nutrition and hydration be written on the proxy form? The answer is no. It just has to say on the proxy form, I have told my agent what my wishes are, and they are authorized to act on those wishes. What if an agent's decision appears to conflict with the written instructions by the patient? This is the conflict that Adira was describing when the healthcare proxy says one thing and the living will says another. Clearly, the patient's expressed wishes in writing or otherwise control. So the standard of care comes into this discussion because doctors make their own decisions according to the standards that Adira described, where they have a say in what they will and will not do for a particular patient. The fact that a patient puts in a healthcare proxy, I want open heart surgery if I have a headache, does not obligate a cardiac surgeon to do open heart surgery on a patient with a headache. The problem we have legally with this misinformation about feeding tubes is that some judges latch on to the notion that withdrawing a feeding tube is starving the patient to death, is murder. Does everyone wind up on a feeding tube? Not anymore, because the standard of care has come to recognize that feeding tubes, unless they are a bridge therapy for an acute event, actually don't provide any clinical benefit, and doctors are not obligated to provide medically futile care. So Bornstein is an interesting case from 2005 where an appointed healthcare agent went to the hospital's administration and said, I want to exercise my authority to withdraw artificial nutrition and hydration, and they got in a fight about whether the patient had been clear in expressing the patient's wishes about artificial nutrition and hydration. The person who filed the petition, who was trying to unseat the healthcare proxy, the agent, tried to get her completely removed, and for the petitioner to be substituted. The judge decided, no, the agent doesn't have authority, doesn't have sufficient evidence of the patient's prior expressed wishes, but that doesn't mean that the healthcare agent did anything disqualifying. So the PEG tube stayed, but so did the healthcare agent. This was in Queens County. There have been different decisions in different parts of our lovely state where judges have reached very inconsistent conclusions, and that is part of the problem we face. So as bad as judges getting involved in civil claims over who has the authority to make decisions, when these kinds of issues wind up in the criminal venue, life gets so much more complicated. This is an article from a case in Ohio in 2018. 3 nurses were indicted in the death of a nursing home patient because they had forged the night check documentation and had in fact not done the night checks that they were obligated to, and the patient wandered off, and of course it had to be winter, and therefore the patient froze to death. And I bring this up at this point in our discussion because this notion of adult care facilities having this heightened obligation to protect their residents from imminent harm spills over into lots of different areas. So 2 of the nurses involved in this situation actually pled guilty and were sentenced. The third was fined because all she did was facilitate the alteration of the paperwork. These are actually the nurses who made it up and didn't check on the patients when they should have. This is bad. This is worse. Just so happens also from Ohio, Dr. Husel was indicted on 25 counts of murder for giving excessive doses of fentanyl, really excessive doses of fentanyl, 20, 30, 50 times what would be considered a therapeutic dose. This case is working its way through the courts now. It's important because this is a doctor who wasn't sneaking in the middle of the night and killing patients out of some sadistic desire to cause death. He was going into the Pyxis machine, which is in a hospital, it's the medicine and medical supply vending machine. You press some buttons, a door pops open, you take out what you need. The system had provisions for limiting how much fentanyl a doctor could draw for a particular patient, but because there are emergencies sometimes, the system has an override. And the nurses at this hospital, at the request of this doctor, were punching in their access code to override the limits routinely for months, may even be years. And it's this kind of failure of oversight and protection systems to work that leads to even further suspicion and distrust of institutions, which leads to further reluctance to adopt aggressive support for patients' advanced directives and expressed wishes, and that's part of what we're up against. That's what fentanyl looks like. It's a clear liquid. It's really easy to administer. I could teach any of you how to do it in about 15 minutes, and it is all over hospitals. And this is directly related to the larger epidemic of abuse and distribution and diversion of pain medication that we're up against, another influence on institutions not wanting to stick their necks out to provide aid in dying because you can wind up being accused of homicide. As bad as the drug problem is, the death panel thing is worse. Death panels. Most of us remember death panels. If you don't, look it up. This is from a organization that supported the labeling of the Affordable Care Act, Obamacare, as death panels. They concluded that this really was a form of government adjudication of who should live and who should die. PolitiFact in 2009 labeled this the winner of the Lie of the Year contest. This is what Sarah Palin, who you will recall was running for vice president at the time, said. Seniors and the disabled will have to stand in front of Obama's death panel so his bureaucrats can decide, based on a subjective judgment of their, quote, level of productivity in society, whether they are worthy of health care. This is what killed the effort for a decade, a little less than a decade, 8 years, of efforts to get reimbursement through Medicare for exactly the kind of advanced care planning that Adira was talking about as being needed in order to help patients define what their values and preferences are for treatment and put them in writing. We're still living with the effects of Sarah Palin's death panel label on the Affordable Care Act. And if that weren't bad enough, we have the federal conditions of participation, which are just the fuzziest kind of federal regulation you can imagine, and actually have more impact, negative impact, on the lives of patients in adult care facilities than even the death panel scare. So this is the rule, 42 CFR 488.301. It defines abuse, neglect, immediate jeopardy, lots of other things. But for our purposes, the immediate jeopardy provision is what we're concerned about. Immediate jeopardy means a situation in which the provider's non-compliance with one or more requirements of participation, that's the COPs, has caused or is likely to cause serious injury, harm, impairment, or death to a resident. There's a complicated definition of abuse and neglect, but that's not what we're really worried about in this context. We're worried about the fear that institutions have, adult care facilities, that they will be accused of causing immediate jeopardy if they respect the wishes of a patient, either with regard to VSED or medical aid in dying, which, as Adira pointed out, isn't just taking life-ending medications, although that's the definition ascribed to it in the legislation that we'll talk about in a little bit. Come on, there we go. So, really in the weeds, and I share this just so that you're familiar with the concepts because it's complicated. These are the guidelines in the State Operations Manual, which is a little deceptive because it's the federal State Operations Manual. It's the rules that the federal government gives to the states. This is what you have to do to make sure that no adult care facility is creating a risk of immediate jeopardy. So it's everything from failure to protect from undue adverse medicine consequences to, down at the bottom, failure to protect from infection. And then in the middle, there's this E. We're here for E. Failure to provide adequate nutrition and hydration to support and maintain health. Let's take a closer look at E. Failure to provide adequate nutrition and hydration to support and maintain health is broken down into 3 factors. food supply inadequate to meet the nutritional needs of the individual, meaning you just don't have the food available. This, by the way, dates back to the nursing home scandals of the 70s in New York, where literally they just didn't have food and therefore didn't feed people. Failure to provide adequate nutrition and hydration resulting in malnutrition. That's what we're here to talk about. 3, withholding nutrition and hydration. That's specifically what we're here to talk about, but without an advance directive, meaning that it is immediate harm or jeopardy if you withhold nutrition and hydration unless it's pursuant to an advance directive. That's federal law. So this phrase, without an advance directive, as it relates to failure to provide adequate nutrition and hydration, because these are the factors, adequate. This is the important word, right? Because if the patient is refusing to be fed at all, and if Justice Cardozo said that under the Schloendorf standard, patients are allowed to decide what is done to their body, then if it's pursuant to an advance directive, no food is adequate because the patient doesn't want any. That's the federal standard. So the way this works, this is bureaucracy at its finest. In the manual, which the surveyors use to know how to do their job, the federal government gives the surveyors and the facilities, by extension, examples. So this is an example of something you might find. Surveyor finds that the chart does not include a copy of the patient's advance directive. The progress note does not contain any documentation of the patient ever stating a wish to have nutrition and hydration withdrawn at the end of life. No advance directive in the chart, no notation that the patient said, I don't want nutrition and hydration at the end of life, equals immediate jeopardy. This is a good rule. So the institutions take that information and they kind of twist it into knots. So this is a paragraph from a letter written by the lawyer for an adult care facility that will remain nameless. Ignore that word Kendall. That's not the name of the facility. It isn't. This was a letter written to a patient at a particular facility somewhere in New York State. And they said, the rules and regulations governing all levels of health care offered in the state of New York require that licensed health care providers offer adequate nutritious food to its patients. That means that Kendall, that's the parent national company. I'm not going to editorialize about Kendall. I don't want to be sued. As a provider of health care, is required under applicable regulations to provide at least 3 meals a day. Provide. Does provide mean force down the resident's throat, or does provide mean make it available? We'll find out. And then they go on to say this is true regardless of whether the resident resides in an adult home, an enhanced assisted living unit, or a skilled nursing bed. And yes, there are distinctions. I won't bore you with that. So the state's regulations, 10 NYCRR 415.14, says that the facility shall provide each resident with a nourishing, palatable, well-balanced diet that meets the daily nutritional and special dietary needs of each resident. And the important word in this sentence is needs. If the patient doesn't want to be force-fed and the patient wants to be left alone, then the patient's need for daily nutritional and special dietary support is 0.
Can I pop in for 1 second?
Please.
Okay, so I just wanted to sort of like paint a little bit of the picture of why this feeding piece is a little complicated. Well, part of this feeding piece is a little complicated. I think we've been doing that the whole time. Is that there are people who at the end of their life, many people, almost all of us, stop wanting to eat, right? So we sometimes it's forgetting how to eat, forgetting the process of eating, and sometimes it's our bodies start to, as they start to die, start to not absorb nutrients the same way. Again, caveat for those of you watching at home, I am not a clinician, so this is based on my experience in the hospital. So there are patients that stop eating because this is part of the natural dying process. That needs to be distinguished between patients with capacity who are voluntarily asking not to be fed for the purpose of expediting that dying process. And then there's the other category, which I think I was mentioning before. So not necessarily force feeding, but patients who might have made that request at some point or that desire, but are now asking for food in a differently capacitated or incapacitated state. So those, just bearing in mind as David talks through those things, that this patient can look very different.
And often will. So this is my quibble with the unnamed facility owned by the Kendall Corporation. They cited A, ignored C. Information on each resident's prescribed dietary regimen shall be available and shall be used in the planning, preparation, and service of resident meals and snacks. Understand, these regulations were born of the nursing home scandals of the 70s when patients were, in fact, being horribly, horribly neglected and abused. But the words mean what they say. Each resident's prescribed dietary regimen, that is prescribed either by their individual doctor or by a dietitian, and that can include, pursuant to an advance directive, a prescription for no oral feeding when you reach fast level 7, and that regimen and information about that shall be used. The word shall has been in the news a lot lately, having to do with referrals of whistleblower claims. It's the same shall be used in the planning, preparation, and service of the residents' meals and snacks. So I would say, I have said to the unnamed upstate nursing facility that will remain nameless, that is state law regulation consistent with the conditions of participation that say, with an appropriate advance directive, written or oral, under New York state law, patients ought to be allowed and ought to have the right to refuse unwanted nutrition and hydration, either by an explicit contemporaneous statement, I don't want any more food, or pursuant to an advance directive. So these rules are enormously detailed. This, for example, is the rule about congregate meals, group meals, because that was a way that some nursing home operators got around the requirement to provide each patient with 3 individual meals and a snack each day. I like the fact that the state of New York guarantees a snack. So this is where we are now in the legislative, or potentially the court battle, between those of us who want to use the law to enhance the rights and opportunities of patients, and those like the unnamed healthcare facility who say that is not one of the powers that a healthcare proxy has under New York state law. So the problem lies in the definition of the word healthcare, and there's a definition of healthcare. Healthcare means any treatment, service, or procedure to diagnose or treat. You shouldn't use a word twice in the same sentence. Shame on them. Treatment and treat. An individual's physical or mental condition. So is the desire not to be fed a physical or mental condition? I'm not sure. Plainly, when the healthcare proxy law was passed, we were all very focused on artificial nutrition and hydration, because feeding tubes, peg tubes, were in much wider use then than they are now. And frankly, nobody thought that we would wind up in a fight over somebody's ability to refuse spoon feeding, but here we are. So what we need fixed, this last paragraph is my handiwork. This existing definition of healthcare should have inserted at the end the words including nutrition and hydration, not artificial or oral, all, so that the paragraph reads, healthcare means any treatment, service, or procedure to diagnose or treat an individual's physical or mental condition, including nutrition and hydration. This will probably take, I'm not going to say it. It took us 17 years to get the Family Healthcare Decisions Act passed. I'm hoping we can get this done faster. More on that when we wrap up at the end. So what do we have to do? We have to make sure that every doctor and every lawyer and every social worker and psychologist knows that as part of their standard of care, they have an obligation to make sure that patients put their wishes down in writing while they still have decisional capacity, so that those instructions can be part of the argument for what the patient actually wanted. And the federal government, at least, is trying to help us in this process with some money. So in January of 2016, a new set of reimbursement codes called CPT codes, current procedural terminology, don't know where they came up with that name, 99497 and 99498 actually provide payment to clinicians, doctors, nurse practitioners, lots of other people, to engage in advanced care planning. What is advanced care planning? It is the process of counseling a patient or their family members about what they need to be prepared to make decisions about, and helping the patient put that down in writing. It's not a lot of money, but it's a start, because it says this is important enough to the legal and ethical provision of healthcare that the federal government is going to pay for it to make sure it happens. Unfortunately, since 2016, we have not seen an enormous explosion in the number of advanced directives that are showing up in hospitals or in hospice programs, and that's why we're here today. This has got to be the start of a concerted, widespread effort to encourage clinicians to get trained so that they feel comfortable engaging in advanced care planning and can incorporate it into the routine part of a office visit or a preventative annual physical or any other setting, preferably something short of when you land in the hospital with some acute and or chronic condition. So how could this not work perfectly? Well, we have a regulation for that too. New York State Regulation 10 NYCRR 766.3b says, a plan of care is established for each patient based on a professional assessment of the patient's needs and includes pertinent diagnosis, prognosis, need for palliative care, mental status, frequency of each service to be provided, medications, treatments, diet regimens, functional limitations, and rehabilitation potential. And the adult care facility has latched onto this as proof in their minds that they have an obligation to provide a plan of care that provides for keeping the patient alive. So this needs to be fixed. Here we are back at the State Operations Manual. This is, again, the federal law that says that it is only immediate harm or neglect if you're withholding nutrition and hydration without an advance directive. That, coupled with a change in the definition of healthcare in the healthcare proxy law, can get us to where we want to be so that maybe we don't have to have these fights about voluntarily stopping eating and drinking, either as an expressed wish or on the grounds that a patient said so in an advance directive in the presence of or in the absence of dementia. There's some reason for hope. Let's take these backwards. We're all here. This is a bunch of people in virtual reality who are here also. These discussions are going on throughout the legal, elder care law, healthcare law, bioethics law communities, in medical communities. So there's starting to be more discussion, in part, by the way, fueled by the reality that we saw in the legislative hearings about the medical aid in dying law, where a lot of us who have been at this work for a very long time realize that we have work to do in educating the people who are opposed to medical aid in dying as an option that should be safe, legal, and rare. Yes, you've heard those words used together before. There's also a lot of public interest. So End of Life Choices New York has public events. They're having one, in fact, at the end of October. It's the annual Barbara Schwartz Lecture. It's at All Souls Schools on the East Side. I urge all of you to attend. The speakers this year are Dick Gottfried, chair of the New York State Assembly Health Committee and the person who championed and facilitated the DNR statute, the Healthcare Proxy Statute, the Family Healthcare Decisions Act, and every other important law in the last 40 years. He and Amy Paulin, a legislator from Westchester, will be the speakers this year, advocating for a broader discussion of their medical aid in dying legislation. So that's good. There's lots of other pending legislation to tweak and refine the way we address how the law ought to frame but not constrict the ability of clinicians to make good decisions based on an evolving standard of care. So, you can get paid for helping patients express their wishes not to be force-fed. You can do it if the patient has expressed those wishes in writing when they had decisional capacity, that they've appointed a healthcare proxy, and not just anyone, someone who will be their advocate. And they've completed all of the documents: healthcare proxy, living will, videotape, advanced directives specifically for dementia care, advanced directives specifically for dementia care involving withdrawal of artificial and oral feeding and drinking. Oops. So what should you do? Well, you showed up here. Thank you. Important first step. Start reading. This is an article written by my friend Judy Schwartz, the clinical director for End of Life Choices New York, on the idea and the clinical implementation of an advanced directive for Alzheimer's patients. Make sure that this is a discussion in your communities, in your professional space, in your families so that more people are talking about the need to reconcile the right of patients to make decisions about their care, the right of patients to refuse treatment, the notion that pushing a spoon past someone's lips, even if it is completely well-meaning, is unlawful if the patient has specifically said, I don't want that done. Schlöendorff. Patients have to have a healthcare proxy because the Family Healthcare Decisions Act, as wonderful as it is, and we all worked very hard at that, it has its own problems. We won't get into that now because it's 10 of 8. I want to leave some time for questions. But we need to reinforce, whether we're in a legal, social service, social work, or clinical environment, we need to reinforce that having a healthcare agent is really important. Because, as Adira said, even if you're doing the right thing and you have the right to do it, doing it is hard, it's emotionally taxing, and if you're not 100% clear that you're doing the right thing, it can be really hard to do. We hope that as more doctors recognize that they can get paid for doing advanced care planning, they'll make sure that that's part of their routine and will make counseling available for families so that they understand in detail what the process is, so that we can get more people comfortable with the fact that making a decision to voluntarily stop eating and drinking in combination with palliative sedation, a whole discussion for another day, can reduce the number of incidents when medical aid in dying is even needed, where we have nowhere to turn but a pharmacologic solution, so that the people who are concerned that medical aid in dying is going to turn into wholesale, involuntary, active euthanasia, that disappears. And if all of that's not enough, come join us at Columbia. We have lots of interesting courses that are just like this. There's one starting in 22 minutes if you want to come across Amsterdam. I don't recommend that.
I know that we want to have questions, but I just want to make a couple of final comments. I'll try to speed through them. So I just want to say that, first of all, I have like we talked about personal, disclosures of our vantage point. I didn't say this at the beginning, but I am very ambivalent about about advanced directives for voluntary stopping of eating and drinking, specifically because of the concern about the voluntariness, right? So as a capacitated individual, I can do something voluntarily. As an incapacitated individual, is it still voluntary? And how do we determine that? And what is that? And I don't want to say that there's never an occasion that I can imagine it happening, but I really want to raise the fact that I think I have a lot of personal discomfort around it, and want to sort of put that out there, that I think that these are topics we should be feeling discomfort about all the time. Even when it's feels like a great solution, they're great solutions because we have created a situation where people are living so long because we're treating diseases that we are now in situations that we never sort of had plans for, anticipated being in, and we're trying to sort of catch up with where this is going, right? So what I would kind of like everyone to think about is thinking about thinking about legislation, thinking about medical aid in dying. That is one approach to this issue, but we can also think about how do we make people's lives as they're dying better? What other interventions are possible? How do we learn more about the processes that people are going through? That this is not just like a battle to fight on one front, that we're fighting. I hate the war and metaphors, but we are
advocating.
We are, we're confronting it. And I also wanted to just say that, to be open to perspectives, that some people, everybody has a different concept of what a good death is, and also brings to this conversation deaths they've experienced, religious values, cultural values. So it's very easy when we're committed to letting people have the death they want to start judging what particular deaths look like. So if we say this death is undignified because somebody's being force-fed through their mouth, but that person chose that and thinks that force-fed is really not the right language, because if their body doesn't want it, I don't think it's appropriate. So let's say somebody who said, I don't mind what state I'm in as long as I can continue to sort of eat and engage, and I don't know who even if I don't know who my family is, or even if I can't do the math problems I used to do, and I'm a mathematician, like, we need to sort of respect that death can look different ways, and that different people can choose different deaths. And that's something that sometimes when we're advocating and get zealous about an outcome can lose sight of. So I just wanted to sort of make that point. And one more point, which is that studies have shown that people who write advanced directives, when they're discussing how they would feel if their family members don't follow their advanced directives, some studies, not like this is like the definitive answer, but some people say, you know what, if it's too hard for them and they're going to have to carry this burden, I'm kind of cool with the idea of them not following what I have to say. So we can't lose sight of how these relationships play out in advanced directives. And so I know the VA and Maryland, at least, some living wills have this language that says, in the event that my loved ones have different information than I might have had or choose differently, I am okay with that. I'm totally, obviously not quoting that verbatim, or I am not okay with that. It's kind of like a checkoff. But I think thinking about, as you speak with your clients, or as if you become clinicians, I don't know exactly who this audience is, thinking about having those kinds of nuanced conversations. You know, what if you really want this, but this is really uncomfortable for family? And some people will say, no, I still really want it, but some people might say not. And so learning to engage with people's stories and making personalized decisions about all of these issues is very important. And I'll stop there.
I agree. Before we go to questions, reminder, if you're here for CLE credit, if you're here in person, you have to sign out and you have to fill out one of the evaluation forms. You don't have to write much, but you have to put your name down on it. And so don't forget that. I don't want anyone to be upset that they don't get their CLE credit. And with that, questions? Please.
You've spoken eloquently about giving patients autonomy, encouraging clinicians to work with their patients, or even people like me, lawyers, to counsel our clients. But what you haven't talked about is resources. Significantly, and I don't know what the resources are in your hospital, but the amount of care and attention that goes into bringing in the bioethical team for an individual and a patient is wonderful. Are you able to do it for patients who are coming in on Medicaid? Are you able to do it? And do you do it with patients who are not as educated as any of those of us in this room? I come from a very strange perspective. I'm actually a criminal defense lawyer. So there are all sorts of other issues here. But I am very concerned that this is, and I don't like using these words, it's an elitist issue that we're not spreading perhaps wider.
Let me answer that. First of all, I feel obligated to say one of my best friends is a criminal defense lawyer, so that's okay. We are making these services available widely to patients who somehow find their way into hospice. So I deal with patients all the time who are not well informed, who are not affluent, who are often on Medicaid. And if some clinician was honest enough to say, it's time for you to start thinking about the transition from curative care to palliative care, they have access to lots of services, including my services. End of Life Choices provides all of its services for free. So anyone can call Judy Schwartz up and she will help them. But that only works if the clinician who needs to make that referral knows to make that referral. And that's why we're doing this, and we're going to continue to do this and do more and different kinds of this.
And
I would argue that someone with Medicaid actually has more access to better palliative care and better end-of-life care than some of the other health insurance programs out there.
Yeah,
They
we
just
could.
have to have a clinician that will have a frank conversation about goals of care and about the prognosis.
Can I jump in for 1 second and
Please.
just address this? So first of all, I'm a former legal aid attorney. That was my career. But so in my hospital, like Montefiore, is a real commitment to social justice, and so there's no differentiation between any patients in the setting that I practice in. But you're absolutely right to point out that the statistics on who engages in medical aid in dying, it's primarily white, it's primarily educated, and those are the statistics that I understand as of right now. I have been involved in a task force that's looking to start, that's not looking, it's talking about community-based organizations having these conversations. So some of the having them in homeless shelters, having them in other places, because the conversations where they're starting and when they're starting is really important around healthcare proxies or healthcare agents, and not supposing that certain people have people in their lives and certain people don't. So there was an interesting study I saw that on homeless people, that homeless persons who were asked if they would want to assign a healthcare agent, and many of them had people. They had shelter workers, and there was an assumption that these are people without people, right? So they said, had I known about this, I totally would do this. I just don't have that information. So your point is well taken about access to information.
More questions? I have a further response to your question. 2 weeks ago, maybe 3 weeks ago, I consulted with a patient through the VNS Hospice, where I serve as a consultant. He was at the end of his life. He had COPD. He was in horrible, horrible discomfort, which COPD is an intense discomfort. And he said to the hospice worker, I've had enough, get me a gun. That was his notion of what end-of-life care is. And we train our hospice people as well as we can, and she realized, oh, this is beyond my scope of responsibility, and she called an ethics consult, and we looked at his clinical circumstance and explained to him that, we're not allowed to give guns out, but why do you want a gun? Well, then I want assisted suicide. And we explained, well, we don't have that in New York, so we can talk to you about transferring to a jurisdiction where that's available, but why do you want assisted suicide? His words. And he said, I'm just sick of this. This is no way to live. I mean, being on supplemental oxygen and all of the other implications of COPD is just pretty horrible. And I said, well, what is it you're trying to accomplish? And he said, I want this to be over. I want to go to sleep and I don't want to wake up. Well, if you have COPD and you're on supplemental oxygen, you can turn off the oxygen. Nobody had kind of thought of that. And that's a simple intervention once you understand exactly what it is that the patient is really trying to accomplish. And that's why we're busy at Columbia turning out a new generation of bioethicists.
And I'm going to add one footnote to you, and then you have a class to teach. Many years ago, my mother, these come down to personal stories. Many years ago, my mother got very sick in France. And she went into the hospital, and they did a whole bunch of surgery, and she went into a coma, and the time came where we were consulting with doctors in the U.S. and in France. And her doctor in Milwaukee said, Jill, this is what you need to know about end-of-life care in a Catholic country. And I said to him, I don't want to know, I haven't got time for this. And he must have said some words because some of it stuck. 16 days later, my mother is in a hospital room in Nice, and she is only being kept alive because she is intubated and is attached to a whole bunch of machines. But in France, you can't tell them to turn off those machines. They won't.
Mm-hmm.
But what you can do is say, no more heart medication, no more insulin, no more medication, except what's necessary to keep other people in this hospital from getting sick. That is infection control, that you can give her. And she died 30 minutes later.
Our next event will be a deep dive into advanced directives and what you can do to control your outcomes. Samir.
Well, thank you very much, David and Adira. Adira, I just wanted to ask you a quick question. Thank you for pointing out the advanced directive and kind of the nuanced perspective some of the states are taking in light of, family decision-making or family kind of viewpoints. I was wondering, how do you address issues surrounding capacity? Let's say today, if I have an advanced directive, anticipating what could happen, do I even have capacity for that? Do you know what I mean? Having not even gone through a situation.
Yeah, so
And how do we kind of wrestle with that issue?
all our systems are imperfect, right? So they're created because we need something to help us, but they're not great. And some are better than others, and some people's advanced directives, and I've known some people who've worked in hospitals that are like, my advanced directives, it's like 42 pages of things I don't want, because every time they see something they don't want, they write it down, and that kind of thing. So research shows that that in general, we are not great at knowing how we will be, like our affective forecasting's not awesome, right? So a lot of that research comes out of the disability movement to say people think that they won't have a great quality of life, or if they had particular disabilities, and then they're in that situation and they're like, hey, I didn't think that I'd be able to manage that. So we're not good at it. So except that we are the people that best know our own values, right, and our own preferences. So if anybody's gonna kind of try to guess, who better than us doing it for ourselves? So I think that it's like a system that's supposed to help clinicians, family members, and help maximize people's, advanced directives are autonomy extenders, right? Because if you are capacitated, you can just say in that moment what you want. It's this idea of, in the time when you lack capacity, your autonomy is sort of still being honored in that space. So I kind of probably should have just said yes to what you said. Yes, this is really complicated. Yes, you can't know what you might like, and you might have a great quality of life, and there are a lot of people with dementia that are happy and that are, depends on what stage. I'm not saying like all dementia, but I think it's hard to sort of anticipate that. That's why we do the best we can, like kind of what David was saying. The videos are ways of just like talking about what I keep saying the word value, and I'm actually very uncomfortable with the word values because I don't even know what it means, but what our preferences are like, what we enjoy engaging in, who are the people we want to be surrounded with, what are the things that make us happy, and talk about that. And that's easier, I think, for family members and to say, actually, this is the situation I think he might have anticipated. So if we're talking about the preferences piece and what kind of life is life worth living for us versus I don't want this tube, I don't want that makes the decisions richer and I think somewhat easier. I don't know, that was a very long answer to your question.
Stay tuned to sps.columbia.edu/bioethics. We do events like this about every month. If you have suggestions for topics that we need to dive into deeper, please, that's my email address. I'd be happy to hear from you. We're going to wrap it up for tonight. Thank you, Adira.
Sure.
And thanks to all of you for attending. You are part of our movement, so get moving. Thank you. Good night.
The materials?
If anyone
Oh, this
needs
is
a
extra? Okay.
extra copy of the materials, they're here for you. And thank you. Come, Joan.